To do is the Pulp Mills on the River Uruguay case. The Pulp Mills on the River Uruguay is a keystone case that clarifies the relevant standards for a breach of environmental obligations. It also contributed further elaboration of customary international law. Regarding this keystone case, court proceedings were initiated on May 4th, 2006, when Argentina filed an application against Uruguay for an alleged breach of the Statute of the River Uruguay. The Statute of the River Uruguay was a treaty solely between Uruguay and Argentina, and for simplicity, will be simply referred to as the statute throughout this presentation. It is a bilateral treaty, as it was negotiated and signed strictly between the two neighboring states. It was signed on February 26th of 1975 and came to force on September 18, 1976. So the statute governs natural resources and activities along the River Uruguay. So the River Uruguay is a river that runs directly in between Argentina and Uruguay. So hence the statute came into place to add like a guiding principle regarding how it should be used and any disputes regarding that. Outlined in Article 1 of the statute, it was created in order to establish the joint machinery necessary for the optimum and rational utilization of the River Uruguay, in strict observance of the rights and obligations arising from treaties and other international agreements in force for each of the parties. So, this statute requires the parties to coordinate through a commission the necessary measures to avoid any change in the ecological balance of the river. The commission that arose from the statute is the Commission of the River Uruguay, which will be referenced as CARU to make things simpler throughout the presentation. This regulatory body directs and manages any works that may affect the river. This statute and commission is of the utmost importance, as through the coordination of these two countries, they have the ability to limit any human impact and protect the river to its utmost quality, and ensure the river quality remains uncontaminated through pollutants. Regarding the dispute, Argentina made the application that alleged that Uruguay had breached its obligations under the statute by authorizing one pulp mill and constructing another on the River Uruguay. The first pulp mill was constructed in 2005 by the Botnia SA and Botnia Frei Bentos SA companies. The second mill, however, was eventually abandoned in 2006. For clarification, because I had no clue what a pulp mill was before doing this and studying this case, a pulp mill is a manufacturing facility that converts wood chips or other plant fiber sources into a thick fiber board. The process can include mechanical, semi-chemical, or fully chemical methods. So as the mill was placed directly on the border, on the adjacent to the river, Argentina believed that they would pose a threat to the river and its environment. They believed that it was likely to impair the quality of the river and cause significant transboundary damages to Argentina. Hence, in order to stop this, Argentina they sent applications to the International Court of Justice, the ICJ, in order to appeal anything that had been made or put there. This proceeding lasted just under 4 years, with the final judgments taking place on April 20, 2010. So pretty much coming up just past it, 14 years. This presentation will look at some of the decisions made, how those decisions were made, and also how the statutes were interpreted, and further how international law as a whole has evolved through this case, as obviously this Keystone case really drove in new decisions that ended up changing how the ICJ looks at cases. Further, so to truly understand the dispute, it is essential to understand certain aspects and articles of the statute of the River Uruguay. So Articles 7 to 12 of the statute provided a process for prior notification and consultation for activities that were likely to affect navigation or the water quality of the river. So Karu is tasked with the mediation and the deciphering of any potential threats. If there are potential threats to the river, there is a 180-day negotiation period in which Argentina and Uruguay must, in good faith, attempt to make an agreement regarding the dispute. So Uruguay had planned to build a pulp mill. They had plans through the construction of them. However, they did not make the appropriate steps to notify Peru of these plans, of these pulp mills. And then when negotiation was finally able to take place, it availed to no success, unfortunately. So, therefore, it moved on to the ICJ. So, the obvious next steps depicted under Article 60 of the statute is that any dispute concerning the interpretation or application of the treaty that cannot be settled by direct negotiation, which we know that has already failed, it may be submitted to the International Court of Justice, the ICJ. So, hence, Argentina submitted an application that alleged through the building of these pulp mills, Uruguay had committed 6 breaches of the statute and other international law. The first being the obligation to take all necessary measures for the optimum and rational utilization of the river. The second, that the obligation to provide prior notice of processes and activities associated with the mills. Third, the obligation to preserve the aquatic environment and its fisheries and biodiversity. The fourth, being the obligation to prevent pollution. The fifth being the obligation to prepare a full environmental impact study, which will be talked about very in-depth further, and the obligation to cooperate in the preservation of the environment and prevention of pollution. So these 6 breaches fall under the category of 3 separate articles of the statute. These 3 articles in which Argentina argued were breached were 60, 7, and 41. This potential breach of articles will be analysed individually below. So, as mentioned, Article 60 concerns the interpretation or the application of the treaty, in which, if there is conflict, it is submitted to the ICJ. So, Argentina claimed that these pulp mills would cause significant pollution, including air, noise, and overall effect of the aesthetic of the river. As we know that the ICJ had the jurisdiction to hear the dispute, the first thing that Uruguay did was claim that the ICJ's jurisdiction was limited exclusively to claims arising under the statute. So, for example, the statute references in 36 its aims. So, it aimed to have the necessary measures to avoid any change in ecological balance and to control pests and other harmful factors in the river and the areas affected by it. This meaning that the goals and the objectives of the statute to protect the quality and pollution of the river also acts as a limiting factor. So, thus the court agreed that the statute only applies to issues regarding the water quality, and hence the Argentina's allegations regarding the air, noise, and overall aesthetic could not be heard because it was, unfortunately, the statute had specifically specified the river, and hence the ICJ did not have the ability to argue a wider range, which obviously narrowed Argentina's scopes within the arguments, which was obviously not ideal for them. So, furthermore, the ICJ began its analysis of the claims from Argentina with the consideration of the underlying duty to prevent environmental harm. The principle of prevention has been adopted as customary rules seen through the decisions in the Stockholm and the Declaration of the Human Environment. The principle ensures that countries' sovereign rights to exploit their own resources do not cause damage to any environment of neighbouring states. This customary law has a large role in this case, as this case aims to ensure the actions of one state do not lead to the detriment of another. as of Uruguay's wanting to make the pulp mill, and Argentina's wanting to keep the its river clean and unpolluted. So the ICJ held that the obligations to notify Peru is a key component to ensure the fulfillment of the duty to prevent this environmental harm. As I'm about to mention, the notification process was outlined in the Articles 7 to 12 of the statute. Run through Article 7 of the statute. 7 Part 1 dictates that a state with a development plan that could affect the River Uruguay shall notify the Commission. The Commission then had a maximum of 30 days to determine whether the plan may cause significant damage to the other party. So, under Statute Part 2, it depicted that after the Commission is notified and a decision cannot be made, the party shall notify the other party of the plan through the said Commission. And the notification under Part 3 must contain the main aspects of the work as well as the assessment of the probable impact of the works of the River Uruguay. So, hence, Uruguay, in wanting to make this pulp mill, needed to consult and alert Peru of its plans. If Peru comes up with an analysis that it could be dangerous, or they cannot, they're not 100% certain, they will let Argentina know, in which Argentina can look at the plans and decipher whether they feel that there's an impact. However, as I'm about to mention, so Uruguay had transmitted the assessments of the pulp mill to Argentina, but it had been after the initial environmental authorizations for the mills were made. So they didn't take the appropriate channel through Peru, as they notified Argentina without the use of Peru, and they also did it after the environmental authorizations were complete. So they basically did what they needed to do. They did what they wanted to do first, and then notified, which the ICJ ruled that Uruguay had in fact failed to comply with their obligations, as they didn't comply with any of Statute 7 or any of its 3 parts. So this article was essential, really, for the notification process, as it allowed for the varying views and perspectives regarding the potential impacts of these mills. So Uruguay, by ignoring their duty, had breached its procedural obligations under the statute. For these reasons, it was ruled 13 votes to 1 that Uruguay had breached its procedural obligations under Articles 7 to 12 of the statute. Argentina then alleged that Uruguay had breached Article 41 of the statute. It was alleged that Uruguay did not fulfill its obligations to prevent pollution. So Article 41, Part A, obliges that parties to adopt legal rules and measures to protect and preserve the aquatic environment and to prevent its pollution by prescribing appropriate rules and measures in accordance with international agreements and keeping, when relevant, the guidelines and recommendations of international technical bonds. So this article stipulates the importance of due diligence to ensure that everything reasonable is done to ensure that the protection of the river quality. So under Article 41 Part B, 1, it stipulates the necessity to not reduce the technical requirements in force for preventing water pollution. Argentina even took one step further and made the argument that Uruguay had failed to use the best available techniques to avoid pollution from the mills. So this wasn't directly specified in the statute. However, it falls under Article 5D of the POP's Convention. So the POP's Convention essentially ensured that for due diligence to have said to be occurred, that the best technologies or best techniques need to be used to ensure that pollution is kept to an absolute minimum. And also this application of other conventions through Article 41A, which I've mentioned already previously mentioned, which allows other conventions the ability to implement guidelines which aids further assistance in the diversion of pollution of the river. So the allegations made by Argentina regarding the pollution can only be to the extent of the quality of the river water, which I've previously mentioned as well. And throughout the allegations from Argentina, Uruguay had maintained the fact that the mills that they created were in fact BAT compliant, meaning it had the best technologies to offer, and any allegations from Argentina to the contrary were not substantiated with enough evidence to actually support their claims. So, as there was no evidence that substantiates the harmful effect that had been introduced into the aquatic environment from the mills, the ICJ had no choice but to rule that there had been no breach of Article 41 of the statute. So it actually, through the people, it was voted 11 votes to 3 that Uruguay had in fact not breached its substantive obligations under Articles 35, 36, and 41 as previously mentioned. Through this case, it is clear to see the evolution of international environmental law. Said in a dispute regarding navigation on related rights, in a judgment, it was specified that there are terms utilized in treaties that have the capacity to evolve, and with that, make room for the development of international law. So, customary law has been briefly mentioned regarding the precautionary principle and its consensus to be universally adopted. It was adopted after continuous use and agreed upon through consensus. In this case, through the interpretation of Article 41A, with its obligation to protect and preserve, it has been agreed to make an environmental impact assessment part of customary law. This is where there is a risk that proposed industrial activity have a significant effect on a transboundary context, in particular to a shared resource. Hence, under paragraph 204 of the judgment, if a party wishes to complete its due diligence, and the duty of vigilance and prevention would not be accurately completed unless they've undertaken an environmental impact assessment on the impact of such works. So the ICJ confirmed through their judgments of this case that the preparation of a transboundary environmental impact assessment is required by custom, where a proposed activity poses a risk of significant environmental harm. Although it has been specified that the content of the EIA be subject to the jurisdiction and specificities of each case, the onus of due diligence has now been outlined through this case, depicting the fundamentals that need to be met. Further, there are some controversial decisions and acts that arose from this case. There appeared to be some controversy regarding the evidence utilized, as well as the admission of expert evidence. Argentina had video footage that they wished to implement as evidence regarding pollution. However, the court would not allow the video to be implemented into court and did not cite a statute, rules, or anything to substantiate its decision. So, unfortunately for Argentina, they had evidence that they thought would benefit their case greatly. That was unfortunately not heard in the court. And further, there was also extensive scientists and technical evidence produced by both parties to the proceedings. However, the ICJ criticised how these expert witnesses should never have been included in the council, as this prevented the expert witnesses to be questioned by the other party as well as the court, greatly limiting the strength of any statements. So it also just inhibited the court from achieving a complete and clear picture of the possible pollutants. So it kind of set a precedent to ensure that for when evidence and when a expert witness is being called, that they should not be put in counsel. Otherwise, it kind of removes their right to be questioned by the other party, which kind of in all really limits the strength of some people's arguments. So Argentina had failed to effectively prove the fact that the mills would cause pollution and negatively affect the River Uruguay. The evidence that they wished to submit was not substantial enough to prove this. Therefore, no substantial obligations had been breached of the statute depicted from Uruguay's actions. However, although Uruguay did not act to its procedural obligations in the initial process of the mills, as they did not notify Peru and Argentina properly through the processes in place that were in the statute. But so with overall, this case outlined the evidentiary threshold required for a breach of environmental obligations, and it massively set the precedent that the environmental impact plans were now customary law in international law, which has really reshaped obligations arising under treaties, and creates a new precise definition of due diligence and what really needs to occur for it to said to have been done. So, in all, so the 1975 statute places the parties under a duty to cooperate with each other to achieve the object and this purpose stipulated in the statute. These two countries have a long-standing obligation to cooperate, which ensures that any facilities such as the pulp mills are not causing pollution and damaging the rivers that runs between their two countries. These two countries, through acting jointly with Korea, have established a real community of interests and rights regarding the management of the river, and they've done this in the betterment of the protection of the environment as a whole. This case speaks on its obligations and demonstrates the importance to adhere to this treaty, to ensure the betterment of the river and for the future maintenance. I hope that you learned something through this presentation, as I've learned lots going through this case, and really had a grander understanding of what some cases can do, and as it sets precedents for other international laws, treaties, and cases that will be heard by the ICJ. Thank you very much for listening.